And as to Mr. Milton, is there a competency concern, or is this
I am not represented by anybody besides myself in my sovereign capacity. Appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt. I'm letting
I read him.
You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented. Thank you.
As the agent for Peyton Ansley John Milton, you are indicating to me that you're quite familiar with Peyton Ansley John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
All right. And you understand, for my purposes, though that language doesn't make any sense. So
no, I do not.
I understand. Okay. Well, I'm telling you that. And so I am, until you disabuse me of the motion or the notion, I am inclined to believe that you are both the agent and the person. So, and it's in all caps. I'm not a person.
I am one of the people. Thank you.
Buckle up, guys. Today we're stepping into a courtroom where logic is about to take a serious hit. The clip opens with immediate confusion as the defendant refuses to even state his name properly, instead claiming to be an agent of himself. This bizarre identity game sets the tone instantly. Before the judge can even establish basic facts, we're already deep into sovereign citizen territory, making this a perfect hook that grabs attention and signals chaos ahead.
Yeah, hold on, we're not done.
Okay.
Have a seat.
You got it.
And thank you. Mr. Sharp, let me swear you in. Swear the testimony, probable cause application to be the truth, whole truth, and nothing but the truth.
I so swear, Your Honor.
Okay, Mr. Sharp.
So this information comes from a report of Officer Evers of the Lacey Police Department. She responded to an unwanted person complaint at a 7-Eleven store. Upon arriving, Officer Evers contacted staff who advised her that it was a white male, approximately 5'5", with a beard, wearing green long-sleeved flannel. Staff advised that he was intoxicated and belligerent. At one point, the male stated he would be waiting outside when they got off work, that they asked the male to leave multiple times and he refused. Once they called the police, the male returned to his Toyota 4Runner, that it was parked outside the gas station. Staff stated that they didn't feel safe, wanted the male trespassed. Officer made contact with the male and immediately was able to identify him as Peyton Milton. Officer knows Mr. Milton is a local transient that lives out of his car, has had several social contacts with him. Officer Evers asked Mr. Milton if he was just inside the store. He stated that he was.
All right, guys, things escalate quickly as the defendant outright refuses legal representation, insisting he exists in some sovereign capacity. While most people rely on attorneys in court, he confidently rejects help, thinking he understands the system better. This moment is crucial because it shows the exact point where his case begins to fall apart. His confidence sounds strong, but it's built on completely flawed logic that will soon unravel in front of everyone.
Officer advised Mr. Milton that he'd be trespassed from the 7-Eleven, and he stated, "I understand what you have to do." Mr. Milton offered to manually push his car to a gravel lot about 25 yards from the 7-Eleven so that he wasn't on the property since he was too intoxicated to drive. Officer agreed and gave Mr. Milton until nightfall to push the car out of the lot. Officer provided Mr. Milton with his phone, and he replied, "Can I go back in and charge it?" The officer advised him that he could not charge his phone at this 7-Eleven and that if he entered the store again, he would be arrested. Officer provided Mr. Milton with a copy of the trespass form. And then at 16:23 hours, staff called dispatch advising that Mr. Milton was back inside the store. Staff advised that Mr. Milton said he was too drunk to be held accountable, and that he left again once they called dispatch, and this time he again left his cell phone in the store. Officer then contacted Mr. Milton. He again stated that he was too drunk to be held accountable. Officer noted that Mr. Peyton was intoxicated but functional and able to understand the officer's instructions. Officer advised Mr. Milton that he was under arrest for trespass, detained him without incident. He was then booked into the county jail. The Nisqually jail.
On the charge of criminal trespass first degree, is the city making a motion to revoke the deferral on the assault conviction or
Yes,
on the
Your
assault case?
Based on the new law violation, yes.
Thank you. And let's see.
All right, guys, The judge directly challenges his agent versus person argument, and it doesn't go well for him. The defendant tries to separate himself from his legal identity, but the judge calmly dismantles that idea with simple reasoning. You can feel the gap between legal reality and his belief system widening. This is the first real clash where authority meets delusion, and it becomes clear that his strategy isn't going to hold up.
Let you know. So sit
Appreciate
tight.
it.
I'm still working through the process. Thank
Of
you.
course.
All right. So, Mr. Sharp, it appears that the assault was not a deferral. It was a stipulated order of continuance.
That's correct, Your Honor.
All right. Thank you. So we'll note the city's motion to revoke the continuance on the assault charge based on the allegation of a new law violation. And Ms. Langley was counsel of record on that case. Well, I will, and Mr. Milton is asking not to be represented by counsel, is that correct?
That is correct, Your Honor.
Okay, so let's have a little chat about that. If you choose to represent yourself, which is your right, you can make that choice, but I want to make sure that we make a record that you are doing so knowingly and voluntarily. Ms. Langley is an attorney. I'm going to guess that you have not gone to law school and become a member of the bar. Is that correct?
I can neither confirm nor deny that.
All right, guys, we finally get the actual story behind the charges, and it paints a very different picture from the defendant's claims. The report describes him as intoxicated, aggressive, and refusing to leave a store despite multiple warnings. This section grounds the case in reality and shows why he's standing there in the first place. It's a sharp contrast between the facts presented and the narrative he's trying to push.
So not being an attorney, you understand that if you represent yourself, the court cannot assist you in recognition of the fact that you're not an attorney. So you will end up missing things you're supposed to do. You will do things you're not supposed to do. And all of those things will likely work to your detriment. So it is never a smart thing to represent yourself. And frankly, if an attorney were to say they would represent themselves, I would have the same conversation with them and advise them, I think it's a foolish decision to make. You, however, have that right, as I pointed out, but I want to make sure you understand you have the right to have counsel. You have the right to have me appoint counsel, or you can hire counsel. And if you ask me to appoint counsel, I can appoint counsel at no cost. So you understand all of that.
I appreciate that, and I do. Thank you.
And how do you choose to go forward?
Pro se, please.
Okay, you even know the right term. Okay. All right, I won't appoint counsel to represent you. You'll have to represent yourself on both cases, the criminal trespass charge and the city's request to revoke these continuance and get a conviction on the assault charge. So that's at risk here with this new allegation. So I want you to be aware of that.
Your Honor, I was not read my Miranda rights this most recent time. I believe I'm supposed to request a voyeur of the...
All right, guys, we hit one of the most unbelievable moments in the entire case. The defendant openly admits to being at the scene but argues that he was too drunk to be held responsible. Instead of denying the act, he leans into it with a completely misguided defense. This moment stands out because it flips logic on its head and instantly becomes one of the most memorable and frustrating arguments in the hearing.
Like I said, I can't represent you. You're going to have to figure all that out yourself for purposes of today.
I'll require 4 to 6 hours of unhindered internet access so that I can properly represent myself. If you would write that into a court order.
Read your form on your constitutional rights.
Did I read my form? I don't believe I was provided anything.
Okay, is there a corrections officer there?
Mr. Upton?
Yes, Your Honor.
Let's present Mr. Milton a copy of the rights form and have him read it. And then he and I can talk about it.
Yes, Your Honor. There's one taped to the desk right in front of it.
Okay, why don't you take a minute and read it? Let me know when you're done reading it, Mr. Milton.
Appreciate you. I haven't been Mirandized, so it's hard for me to even start since I can't technically be charged with anything. And there's no victim in this alleged.
All right, guys, the situation escalates as we learn he was warned, removed, and then returned to the same store anyway. Despite being clearly told not to come back, he ignores the warning and repeats the behavior, leading directly to his arrest. This part shows a clear sequence of choices that made his situation worse, turning what could have ended earlier into a guaranteed legal consequence.
All I'm asking right now is for you to read the rights and tell me that you have done so.
All right. Would you please silence yourself? Forgive me.
And actually, Ms. Langley, if you'll unmute, because I have some questions for you regarding other cases.
Several days later.
I have completed the reading, sir.
All right, thank you. I'll talk about that with you in just a moment as soon as I finish this document I'm working on.
Thank you.
Any question about those rights that are on that form?
Not particularly.
Okay, thank you. All right, so what the question before the court now is whether I'm going to hold you on bail. The city has asked for $500 cash or bond on each case. Just address that issue. Don't address the underlying facts, because to the extent that you do so, any statement you say regarding that can be used against you on these cases. So right now, just address the issue of whether you should be released or not.
Appreciate you. Yes, I would like to request being released on personal recognizance. And the reason being is because there were several things articulated in the statement that were absolutely not true. For one, I was
Okay, yeah, hold
in
on.
possession of a cell. No worries. I was not in possession of a cell phone, as I had my vehicle, my phone, my computer, my passport, and every physical possession stolen from me last time I was under arrest for defending a senior citizen in this community. The same day that Officer Tittle refused to search the man who stole my key.
Okay, anything else?
That's it.
All right, guys, the judge takes a moment to explain why representing yourself is almost always a bad idea. It's a rare moment of clarity and fairness, where the court genuinely tries to protect the defendant from his own decisions. The warning is direct and realistic, highlighting how easy it is to make mistakes without legal knowledge. Unfortunately, despite hearing all of this, the defendant remains completely committed to going solo.
Unless you would allow me to fill in some details that they failed to read me my Miranda rights, and I wasn't taking a statement from in both questioned cases in question.
All right, so what the case of Miranda tells us is that if you make any statements while under arrest prior to being read your Miranda rights, the prosecutor is limited in its ability to present those statements to the court. It doesn't have any other purpose other than whether something you say can be used against you. That's the whole purpose of Miranda. Doesn't mean they can't go forward with a criminal charge.
Oh, I was never aware of that.
Right, which is
Appreciate
one of the reasons don't want to represent yourself, but you know, I've explained that to you now, but I just want to make sure. So you still wish to represent yourself?
Absolutely.
Okay, all right. Seem like a sharp guy, so.
Yeah, he's about as sharp as a box of used crayons.
Appreciate you, Your Honor.
Seem dedicated to it. Okay, based on the outstanding warrant out of Skagit County, I will hold in $500 cash or bond bail on each case, total $1,000 cash or bond. And I'll remind you, you're to have no contact with the 7-Eleven store, no criminal law violations, not consume any alcohol and marijuana, not enter any bar or tavern. And give me some realistic expectation. Are you going to be able to post bail or likely not?
You know, if the minimum that I'm allowed to throw on a bail is 300 and I have to bail out for 2 things, then I'm certain I would need to acquire a phone number that I don't have in order to make that happen. And so I would have to say that it may be closer.
All right, guys, the defendant shifts focus to Miranda rights, but completely misunderstands how they work. He believes not being read his rights means the charges don't apply, which is simply not true. This moment shows a common misconception being played out in real time. Instead of strengthening his case, this argument further exposes how little he actually understands about the legal system he's trying to challenge.
I know from your history that the bail here is usually 10% of what's ordered, so $50 on each case is what a bonding company would want from you. So just, I don't
Cool.
know whether that
Well, I have
changes anything or
$100.
not.
Isn't that
Okay, all right. Thank you. I will set this for 3 weeks from today at 1:30 in the afternoon. So on Monday, the 24th of April, for what we call a pretrial, Mr. Milton. And at the pretrial hearing, you will have received information from the city prior to that as to any offer to settle the case. Just so you know, you don't have to accept it. But they will be contacting you to give you whatever offer they have. And then you'll tell them, the court at that time, whether you wish to accept the offer and enter whatever arrangement is made, or whether you wish to go to trial. So that'll be what we discuss on the 24th.
Awesome. In the meantime, will I be allowed 4 to 6 hours of unhindered internet access so that I can represent myself?
Yeah, I do not regulate the jail, so you're gonna have to talk to the folks at the jail.
If you write it as a court order, I'm certain that they will be more likely to comply than if you don't.
All right, I'm not gonna write it as a court order. Like I say, I don't mess with how the jails run their jail, but
Speaking
they've
of,
heard
by
you,
the
and
way,
Mr. Sharp has heard you, and we'll go forward that
on
way.
a side note, if I may, Your Honor, during intake, and I might preface this with, I have gone to anti-kidnap.
All right, guys, he finally gets a real opportunity to argue for his release and completely wastes it. Instead of focusing on reasons why he should be let out, he goes off track, bringing up unrelated claims and personal grievances. The judge even points out that he failed to make a proper argument. This is a turning point where his lack of focus directly impacts his chances in a serious way.
I was inhumanely subject to what I would define as torturous actions. It was by CO Patero. I have nothing against the man, but he only sought to escalate a situation physically that could have been de-escalated with a verbal warning, a verbal, hey, knock your stuff off, a verbal. And I was completely compliant physically, as you can see on camera if you look in holding C on the night that I was intaken. And when I was asked to be picked up and seated, they had refused and told me on their paper that they checked on me every 15 minutes when I was checked on about 3 times the first 2 hours and about twice in the last half an hour. So,
All right, we got that.
Yep, appreciate you.
All right. Thank you. And we'll see you on the 24th.
All right, guys, everything wraps up with the judge setting bail and laying out the consequences. Even here, the defendant struggles with basic math and continues making odd arguments, including complaints about jail treatment and unrelated claims of training. It's the final moment where everything about his behavior comes together, leaving a lasting impression of how badly this entire situation was handled. If you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and we'll see you in the next one.